Mr. Chairman, let me just say that the gold standard of data protection up till recently was the Internal Revenue Service. And this committee's now looking at the breach of personal information out of an agency that we never thought we'd have to worry about, and any penalties that might have been in place were apparently resolved with resignations. I hope the committee won't cut short its investigation of what went on there. But let me share for my colleagues what Senator Wyden's trying to do. Let me say from the onset, right now, I think he's got the votes. So the onus is on me to try to convince you why this is a very, very bad thing to do. The Wyden amendments pattern off of legislation that would allow the use of the National Directory for New Hires to be used for federal, state, and private research organizations' use for the evaluation of whether federal programs work by tracking individuals' personal wage data. Currently, NDNH is used for very discrete purposes for which the federal government is uniquely suited to provide this data: enforcement of child support payments, enforcement of debt collection for student loans, and the administration of unemployment compensation. These are appropriate uses of this highly personal data and very limited in scope. Now, the problem with Senator Wyden's amendment is that it would expand in a very dramatic way several agencies' access to personal individual information, such as Social Security numbers, employee addresses, dates of hire at their jobs, the name of their employers, the amount of money they make, and the address of their employers. These are some of the most personal information that the federal government can collect and should be used in the most limited of fashions. Now, under the Wyden Amendment, here are the agencies that would have access to this data with individually identifiable records: the Department of Labor, the Department of Education, the Department of Housing and Urban Development, the Department of Justice, the Department of Veterans Affairs, the Bureau of Census, the Department of Agriculture, and the National Science Foundation. It's probably easier to list the ones that have been left out. Now, why is this a problem? These agencies would now have access to personal identifiers, provided the agencies use the information for evaluation or statistical analysis or for reasons likely to contribute to promoting good work outcomes. After concerns with data breaches over the healthcare.gov website, do you really want to give even further access to information for such broad purposes? But let me suggest that this amendment doesn't stop there. It allows, through grants or contracts, the access to Americans' personal information by private research organizations. Now, I have significant concerns over providing such broad access and for such broad purposes this information, because the federal government has an atrocious record in protecting the security of Americans' private protection. In fact, in July 15th, 2013, a memo by the Congressional Research Service on this very piece of legislation, the Wyden Amendment, said this, and I quote, "The expansion of access to and use of personal information contained in FPLS, the amendment, especially in the National Directory of New Hires, could potentially lead to privacy and confidentiality breaches, financial fraud, identity theft, and other crimes. There is also concern that a broader array of legitimate users of the NDNH may conceal the unauthorized use of personal and financial data in the NDNH. Moreover, the concerns about data security and the privacy rights of employees have been a point of contention in many of the debates regarding expansion of the NDNH," unquote. Further, Mr. Chairman, the GAO last year testified before the Homeland Security and Government Affairs Committee that federal data breaches increased 19% in just the past year, and the federal government needed to promptly reassess the amount of information on Americans we currently store here in Washington, but also how we safeguard that information. Let me state that GAO went further. GAO went further than current law and guidance imposes and said only, and guidance imposes only modest requirements for collecting personal data and how it's to be used. They state that this could allow the unnecessarily broad range of the use of information. The Wyden Amendment would add further broad application to the Federal Government's use of personal data. In short, Washington doesn't have some unending claim on personal information of Americans, and we certainly don't have some right to use their data without their knowledge and in ways for which they never granted us permission, and certainly not to evaluate Federal programs. I would urge my colleagues, don't do this. If you do it, it will never be reversed. And no matter, and listen, Ron's been trying to address things through what the severity of the penalty is. You can make the penalty whatever you want to today. Do you really want to risk the individual data of the American people to practically every Federal agency for a mission as broadly placed as what the definition states? Well, GAO doesn't think you should do it. CRS doesn't think you should do it. The American people will be outraged if we do it. But we'll have a recorded vote, and I'll allow every individual member to make that determination themselves. Mr. Chairman, I suggest we have a recorded vote.